And it looks like people are getting pretty settled in, so I think we might as well get started. So thank you everyone for being here. Welcome to our webinar on understanding the legal aid system in Ontario. I really do want to say thank you for making the time to be here. I know that this is an incredibly challenging time for everyone to be just keeping on top of their basic work obligations and family needs, and to be taking time out of your schedule to do extension and professional development stuff is pretty incredible. And so we really, really appreciate it. And we're really happy to be discussing this topic today. The legal aid system has got to be one of the most vital, most poorly understood public services that we have in the province. And it's really just not an easy thing to learn about in concrete detail without having had to navigate the system yourself. Despite the best efforts of lots of lawyers trying to make it legible, it's just not something that most people are familiar with, even sometimes people who've taught law for a lot of years, even a lot of lawyers. We work extensively with law students and with the private bar. And I think you'd be surprised how many people, even in the legal profession, don't really fully understand the suite of what legal aid offers and the context in which it works. So it's a great thing to understand and to teach, and we're really excited that you'll be bringing it into your classrooms. I think most people know that there's something out there called legal aid, but the details really tend to get lost. This comes up for us a lot when we are in classrooms, often playing OJEN's Access to Justice simulation game, which you may have heard us talk about, where we dig into what it's like to actually try to get affordable legal services in Ontario. And we've seen a lot of really common misconceptions from students, including that, legal aid is only criminal law services, which it's not, that anyone who can't afford a lawyer automatically gets legal aid. It's of course much more complicated than that. Most hurtfully, that people seem to think that you get a worse lawyer through legal aid, which is an absolutely horrible, appalling myth that just persists throughout time. So we're probably not going to, completely be able to tackle every public misconception about legal aid, but I'm sure you have a lot of further examples that you could draw from your own classes. We have a phenomenal slate of experts with us today who are going to help demystify some of that process and talk to you a little bit about how much great work happens in the legal aid system. But before we get into all that, given that I believe everyone on our panel today is based in Toronto, I want to acknowledge that we're calling in from the traditional territory of the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and that we continue to benefit from the care shown by those communities to this land over thousands of years. And that extends through the present day, as thousands of First Nations and Métis people and Inuit continue to call this place home. And those communities, of course, are really at the center and have always been leaders in legal struggles for both human and ecological justice that have so much overlap with the work that the legal aid system does. So without further ado, as I mentioned, we're going to have presentations from each of our three speakers that are going to be about 15 minutes each. At the end, we'll save time for questions, so please go ahead and use the Q&A function at the bottom of your screen to submit any questions that you have. We are recording today's session and we'll be making it available on OJEN's YouTube page in the next couple of days. So if anything happens, your connection drops, you want to share this with a friend, that'll all be available too. Okay, so let me introduce our panelists for today. So up first, Simone Bern is currently Criminal Policy Counsel at Legal Aid Ontario. She practiced as defense counsel, including as duty counsel, for about 5 years before moving to the head office, where she initially worked on developing training and educational materials for LAO's criminal lawyers. LAO is Legal Aid Ontario. You're going to hear that a lot. She now works on systemic advocacy and program development, which she loves, but she misses the clients and the buzz that comes from being in court. That said, her two kids provide her with plenty of buzz and remind her all the time about how important it is to teach young people about what justice is, why information is power, especially in the justice system. And following Simone, we're going to hear from Lenny Abramowicz. Lenny is the Executive Director of the Association of Community Legal Clinics of Ontario, a position he's held since the year 2000. Before that, Lenny was the executive director and a staff lawyer at Neighborhood Legal Services in downtown Toronto. In addition, he's worked at and been on the board of directors of other community legal clinics in Ontario. Lenny is the chair of the Alliance for Sustainable Legal Aid, which is a group that represents Ontario's frontline legal aid service providers. He's been on the board of and worked with numerous community-based nonprofit groups. He's written articles on legal issues, on community clinics, and on the topic of nonprofit governance. In 2012, Lenny was given the Legal Aid Leader Award by the Canadian Bar Association. In 2018, he was awarded the Law Society Medal by the Law Society of Ontario. And going in reverse chronological order, Lenny graduated from McGill University with an LLB and a BCL in 1985. And then, last but not least, we're going to hear from Rose Mew. Rose completed her law degree at Queen's University in 2004. She was called to the bar in 2005. She articled with the City of Toronto's legal division and joined LAO as criminal duty counsel in 2006. She is passionate about her role as duty counsel and happy to assist low-income individuals as they navigate the legal system. She's also a scout leader and has organized court visits for youth members to observe the legal system in action. So Simone is going to start us off by talking about some of the core services offered by Legal Aid Ontario. I'm just going to share my screen here so we can get her PowerPoint up. Here we go.
Look at that. Amazing.
Ta-da!
Ta-da! This is great. This is great. This is great. Okay. Hi, everyone. So thanks for joining us. I'm going to kick us off, and I'm going to tell you not only about criminal law, but about some of the core services that legal aid offers in general. We have a great slate here. I mean, Lenny's here. No one can better talk about the clinic system than Lenny. So you've kind of got the la creme de la creme there. So I don't even touch on the clinic system because I'm talking about the services that LAO, that like ourselves, like our kind of head organization provides. So I'm going to go through the certificate services and duty counsel world, which Rose is of course part of. So with that being said, if we could go to the next slide, which would be, or do I go to the next? Oh, no, you do. Okay, perfect. Wonderful. So in general, also, by the way, when I was doing the research for this, the Legal Aid Ontario website wasn't working, which was amazing. So I was like trying to click on things. So this actually comes from our Wikipedia entry, because I was trying to find something that was accurate, but something that was kind of well worded. Oh, go back to that first one, Michelle. Thank you. Which is funny because the Wikipedia entry really needs to be updated. There was a lot of real misinformation there. So it's going next on my list, maybe not today, but anyway, don't trust the Wikipedia site if you happen to want to know what legal aid does in general. Anyway, some of it's right, some of it's not so right. So we are a publicly funded, publicly accountable, not-for-profit corporation. Most of our funds come from the Ministry of the Attorney General, which is of course a provincial body. The MAG is MAG, so I call it MAG, sorry, which is also confusing because I work with a lovely woman named Mary Oxy-Gow, and her initials are also MAG. So when you talk about MAG told me, got to really clarify. Anyway, so MAG provides about 70% of our funding. And then the Law Foundation of Ontario also provides some of our funding. And then we do have some kick in from the feds. I recently last year got a grant from the federal government on creating more data tracking for racialized people in the bail system. So those are kind of one-offs though. I'd say like our primary funder is of course the Ministry of the Attorney General. Doug Ford recently reduced our funding kind of substantially, which you might have heard about, but you know, we're making do as best we can because they are pretty much the bread and butter funder. But anyway, so they're publicly funded, publicly accountable. We get audited every year, which is great fun for our finance department. And then through legal aid, we have multiple ways that clients and applicants can access our services. So we have a toll-free number that you can call from all over the province. And then of course we have the local in-person locations, the court offices. So Rose works at, I think you're at 311 Jarvis? No, Scarborough? Okay, no, yes.
Yes, Scarborough.
Scarborough, perfect. Yes, this is Scarborough. So we have some duty counsel offices, at least in criminal. We actually have a duty counsel office at every single criminal court across Ontario. There's 56. And in family as well, we have some. I'm going to take you through that. And those are staff offices. And then of course we have the certificate system, which incorporates our payments to private lawyers who take on something called the certificate, which is kind of what I think of as like a voucher for services. And then of course we have the community legal clinics, which we fund, but I would say are most separate and apart from what we do. Technically they're funded under the umbrella of legal aid, but they have the most autonomy. We kind of give them a certain amount of funds and then they figure it out on their own. So it's not individual frontline services that we provide. It's the clinics themselves provide the poverty law services. And of course, I'll let Lenny kind of speak to that. I did find out, according to Wikipedia, that we provide more than 1 million assists to low-income Ontario residents every year. I don't know if that number is accurate. It seems low, but I mean, at least 1 million. So anyway, that's kind of legal aid in a nutshell. You do have to be low income, which is a financial threshold, which I will speak again in one of the slides coming up. So in terms of what we provide, again, this is kind of legal aid, the head office and legal aid services that we directly to provide to frontline people. I've kind of split them into staff services, which includes duty counsel services and then certificate. So first, speaking about staff services, there's a bunch of really fun acronyms here. I'm going to take you through them. But ultimately, if it has an F, it's family. If it has a C, it's criminal. If it has an R, it's refugee. And those are really the three main areas of law that we assist with. So FLIC is Family Legal Information Center. CLO is Criminal Legal Law Office. You'd think that we'd come up with like some standardized form, but no, that would be way too easy. FLASC is Family Law Service Center. Duty Counsel, that's pretty easy. So Duty Counsel offices, DC, and then RLO is Refugee Law Office. And then I recently found out, I think that we have like an ILSO or something, which is fun. Found that out. Immigration Law Service Office, I think. And then Senior Counsel. So there's Senior Counsel in both family and in criminal. And some Senior Counsel in Immigration Refugee who work kind of in association with the offices. So these are actual lawyers who work directly for legal aid. They are staff paid. I think of them as like the emergency doctor room lawyers. So they're kind of the ones that deal with you when you're first arrested. For example, in criminal, when you're arrested for and held for bail, duty counsel are the ones that can go. And if it's a simple enough issue that doesn't involve a significant amount of time or it's taking it to trial, duty counsel are often able to resolve the entire issue themselves. They do a lot of complex stuff, but if you require a specialist, that generally goes to a certificate. So that's how it works in criminal. And we have senior counsel or criminal law offices where you might be able to get one of those specialists who also are staff lawyers at legal aid. But I'd say the majority of what we do is duty counsel work, which is kind of frontline services in courthouse. If you think of it as the emergency doctor kind of metaphor, that makes the most sense. So they provide direct case services to people who are, and you do have to be financially and legally eligible for these services, which we'll go into in a slide or two. And then again, it's in family, child custody, criminal, and immigration refugee. So those are our three main areas of law. There isn't, sorry, I put down there's a refugee law office. There's only three staff lawyer offices, and that's one in Toronto, Hamilton, and Ottawa. For duty counsel, so this was kind of going through the information that DC does, and I'll let Rose speak to it quite a bit more, but bail services, guilty pleas, negotiations, resolutions, et cetera. So kind of really the standard stuff that takes place in criminal court. The vast majority of cases in criminal court resolve without a trial. So people don't know that when they think of criminal law, they generally think trials and like these big, massive cases that go to trial and have juries. And the reason you hear about those is because they're so infrequent. The trial rate across Ontario is actually 3.3%, which means that 96%, more than 96% of cases actually resolve without a trial actually happening. So the main bread and butter of the criminal system is duty counsel and senior counsel and certificate counsel resolving, which means that the matter is either withdrawn or the person resolves in a different way. So perhaps they pled guilty, perhaps the matter was diverted. I'll let Rose speak to kind of like what all of those options are as a duty counsel, because she's probably did one this morning. So because it really is the bread and butter of kind of what duty counsel do. I always say when my friends ask me, because I do come from the criminal defense thing, like, oh, well, criminal defense, like, how can you represent people who you think are guilty? And like, I always like to say, and people don't know this, I only learned about this when I was policy counsel, 50% of all charges are withdrawn. So what that means is 1 out of every 2 cases, 1 out of every 2 people charged are going to have the charges taken away, meaning that there's a very good case to say they never should have been charged in the first place. So it's our job to make sure that people are held, the system is held to account. Oftentimes the biggest role of a defense counsel is figuring out the best resolution, which is possibly the best guilty plea. So, no defense counsel just represents, quote, like innocent people. It doesn't make sense. It's not part of the job. And I wouldn't want that to be part of the job, because your relationship with clients and your relationship in the justice system is just as important for the people who are guilty as the people that are possibly innocent. And it's your job to really push the crown and push the system. So that's something that duty counsel do, and senior counsel, and obviously these staff lawyers do. In terms of family, and again, I'm going to be briefer, of course, about family and immigration. I don't have any experience in that area, but family law information centers are kind of similar to duty counsel offices, but they don't provide as much summary, as much front class service. So they're information. So you do provide advice counsel, which is like summary legal advice, but they don't actually track the matter. So duty counsel regularly can take a matter on and then negotiate it, and the client can come back, and the duty counsel can end up resolving it days, weeks, months down the road. But that's not a service that the Family Law Information Center provides, but that is a service that the Family Law Service Center provides, just to keep you on your toes. So that's kind of the difference there. And then immigration and refugee, as I mentioned, Ottawa is the only one with an actual duty counsel office, from my understanding, that gives summary legal advice, which is kind of more similar to the duty counsel realm as opposed to the full RLO, which are hardcore staff lawyers working on cases from beginning to end, and that's the refugee law office. So those are kind of the services there. Thank you, Madir. And that leads us to the certificate services. So certificates are just a fancy way of saying voucher. It's kind of like monopoly money, in the sense that legal aid provides these vouchers to clients to say, you have a voucher for legal services, go find a lawyer that will accept it. So many lawyers accept legal aid certificates and many lawyers don't. Some lawyers who do might only represent clients on legal aid certificates for specific matters. So they might only do drugs and guns or gangs or something like that, kind of more serious things. And then you have lots of lawyers who specialize in youth criminal, for example, or some lawyers who specialize in Indigenous matters, some that specialize in domestic violence. So it really depends on your specialty. Some lawyers do both criminal and family. I'd say that's rare. Most lawyers are, I'd say, either criminal or family, but you do get the full service firm that kind of does them all. Which, it's up to you as up to you as an applicant or a client to decide who you want to give your lawyer to. I mean, your voucher too. So it's you have counsel of choice in that way. And that's a really big difference between certificate services and duty counsel services. Duty counsel, which is the staff lawyers that are employed by legal aid, so the ones that I just spoke of, when an applicant or a client comes in and is eligible for services, they don't get to pick the duty counsel. They get the duty counsel that's kind of assigned to that court that's in resolution services, or that might be in set date court that day or bail court that day. Occasionally you have a duty counsel that specializes in something. So Indigenous duty counsel, for example, or who specializes in Gladue court. And then, so if you're Indigenous and you come in and you're charged with matters and you're in bail court, you might have that particular lawyer come in, but there's not really the same counsel of choice that really works or that really exists as there is in certificate. So in voucher, we literally just give you the monopoly money and say, this is worth this much, go and find a lawyer that you'd like. And it kind of works the same in criminal, family, and immigration. It does cover the matter from beginning to end, but it depends on whether it's hours or services. So in immigration and refugee, it does cover the whole file, but it's kind of like a baseline, and then you kind of add to it in chunks, depending on what services the client needs. And same with criminal. So in criminal, there's kind of like two different ways that you can go about it. If the matter's set down for trial, then the lawyer bills by tariff, which is like hourly. If it's not set for trial, they just get like a big block fee. And in family, the initial certificate, same thing, is 12 to 15 hours. And then they ask for more depending on what the client needs. Oh, next slide, please, s'il vous plaît. Thank you. So these are the tests. So this is pretty important because a person is only eligible for a certificate if you meet both the financial and the legal eligibility tests. The financial test is the one where you actually have to be seen to be making under a certain amount. So people, for example, who are on social assistance or on ODSP will always qualify. Or always be eligible financially for services, and they will always be eligible for at least a minimum duty counsel services. And then we come to the legal eligibility test, and that, of course, changes depending on the area of law. So in criminal, if a person is facing jail time, or if they're from a specialty community, what we consider a priority community, which is racialized, Indigenous, victim of domestic violence, or has some serious mental health issues, and the duty counsel says this matter should go to trial or requires a certificate, because you kind of need that specialist, then you can be legally eligible for that certificate voucher. But otherwise, you would, use duty counsel to resolve. The main difference between duty counsel and a certificate counsel is the ability for someone to represent you at trial. So some duty counsel do trials, but and senior counsel, for example, some of the staff lawyer offices do trials, but pretty much across the board, I'd say the standard, the baseline is that duty counsel aren't putting your matters down for trial, whereas certificate counsel can. Now, as I mentioned before, it's a very low trial rate. So duty counsel generally cover the gamut of everything else other than trials, but they don't do judicial pretrials or prelims, for example. So that would be, if a person requires that, then there's a chance that they would go to certificate instead. So that's the legal eligibility test for criminal. And then for family, again, it's kind of the same thing, but just to kind of stated differently, it's legal and client complexity. So if it's a complex legal matter, or if the client has complex needs, for example, if domestic violence is an issue, or if there's a contested custody dispute, then a certificate would issue and the person would go and find a private counsel to represent them. Child protection, my colleague who works with me in policy said, it's pretty much guaranteed to get a certificate for child protection because they're all pretty complicated. So I said, all right, thank you. The next one, s'il vous plaît. Oh, there we go. Other services. Legal Aid Ontario, of course, I don't provide frontline services anymore. So I wanted to really emphasize, even though there are many people, and I'd say the backbone of legal aid is, of course, providing frontline services, there are a lot of us working in the background trying to make things better on a systemic in a systemic way. So I'm policy counsel, yay! So criminal policy counsel works in line with the strategies with frontline supports to try and kind of advocate for systemic change based on case law, based on program support. So developing different practice directives that might make client service better, application processes, and of course, we always do it in line with the client strategies. And I actually work in the same office with the client strategy council. So we used to have a client strategy council for domestic violence and mental health, but unfortunately, due to budget cuts, we no longer have them, but we still have a strategy council for the racialized community strategy and Indigenous one. So I work closely with them to make sure that communities are taken into account when we create any new programs or when we're trying to increase eligibility or trying to make services better on the front lines. So that's kind of what Policy Council does. I also just answer any question. Like I'm kind of like if the criminal question comes into legal aid, it ends up on my desk. So, and whether that's from frontline service or whether that's from a client or counsel, certificate counsel, et cetera, it's usually me. So I'm kind of the catch-all there. Training and support. So that's actually what I did before I came into policy. I worked on training. So I actually developed the bail and everything but bail training guides for frontline staff. And I held a conference actually for both frontline and staff and certificate practitioners on the nexus between criminal and mental health. Because a lot of frontline duty counsel don't have the opportunity to see what happens at an NCR hearing, or don't know what happens in a fitness hearing, or whose onus it is, or what if it's a balanced probabilities or beyond. Anyway, so all this stuff. So I wanted to kind of create something because it's useful for our staff to know. So that's kind of training and development that we do. And even though I've left that department, there's an entire staff that goes around and starts trying to train and make sure that people are doing and what they should be doing and know what they should know. Central operations, it is a very big organization. You know, we have 300 and something lawyers, frontline lawyers. So getting everyone to be up to date on the case law and different processes. And for example, COVID, we changed a bunch of different things because of COVID, how we take applications, how we interact with clients, who's eligible for certain services. So that all comes out of my department. And then we use the beautiful central operations department to try and push it out to the front lines and certificate staff to make sure they know. Sometimes it lands, sometimes it doesn't. It's a work in process. So anyway, and then LAO law, I'd say LAO law is the most loved part of head office, because LAO Law are the amazing think tankers. They answer questions, legal questions. They create memos. It's like a library of just like these brains just sitting there solving legal issues. So they are they're really loved by frontline staff, not only duty counsel, but certificate staff alike. So that's one of the benefits that we offer. When you do take on certificates as a private lawyer, you get access to LAO Law. So you get access to the entire filing cabinet of anything and everything you could ever want to know, legislative summaries, new case law, stuff like that. So that's our think tank. And then just my test cases are also something that we do, which is very important. I sit on the test case committee, and test cases are the most fun because you have private lawyers who apply and say, here's this massive test case or this case that's coming down, and it's going to go to the Supreme Court of Canada, and it's going to change the way things work. So we get to actually sit there and consider, is this going to have a widespread impact on our clients? Is it beneficial? What groups is it beneficial for? Is it not? Et cetera, et cetera. So that's kind of the test cases. And I think, that's kind of it in a nutshell in my time limit. I'm sorry, I speak very quickly, but this is recorded, so you can go back, or you can also ask me any questions. So that's kind of LAO core services in a nutshell.
Thank you so much, Simone. That was a whirlwind, but it was extremely informative. There's just a lot to cover. There's a lot to cover. Up next, Lenny's going to talk about the community legal clinic system.
Thanks. And yes, there is a lot to cover, and I think Simone did a great job of trying to condense it down. We were joking before the rest of you joined, and I said that I have a 4-hour version of my presentation. So I'm not going to subject any of you to that 4-hour version, but I'll try to touch on some of the main points. I'm focusing, as mentioned, on Ontario's community clinic system. What I'll do is I'll provide a brief history and what are the fundamental characteristics of community clinics in Ontario, and then give you an idea of what the current situation is with the community clinics in this province. So I promise not to go too far back or spend too much time on history, but it is important to some extent in understanding the clinic model and how it's distinct from many of the services that Simone just talked about. You got to go back in history. So legal aid in Ontario did begin in the 1960s, and when legal aid was created, it was part of the expansion of social services programs across the country. You know, whether you're talking about Medicare or Canada Pension, legal aid was part of that in Canada and as well in Ontario. When it was created, when it was first created here in Ontario, it was actually not all those things that Simone talked about, but it was just a certificate model. So that one aspect that existed, and there were certificates at that time. It was just for criminal law and for the most serious criminal offenses. And why that's important is you have to understand that when legal aid was first created, not just in Ontario, but in other parts of the Western world, it wasn't done by accident. There were particular models that were looked at, and the certificate model, which was the most prevalent one in Canada, in the United States, and other jurisdictions, it was predicated on a small L liberal notion of equality that prevailed at the time. And what I mean by this is that the assumption there was that the way you achieve equality, this was the philosophy at the time, and I'm not making this up. If you go to Hansard, and if you go to the debates and discussions that went on at the Law Society, who were initially charged with running the legal aid system in Ontario, these are the things that were talked about, which is that the way you achieve equality in society, certainly in the legal world and access to justice, is by treating everyone the same. You start with the assumption that, well, everybody is a millionaire or everybody is poor, and you don't need to treat them any differently. And the certificate model was created on that premise. And the idea was, as Simone has described, what you do with the certificate model is if somebody shows that they're poor enough, then they're given a certificate, a voucher, and in theory, that makes it all okay. That puts them in the same place as it does Conrad Black or Galen Weston or any millionaire, because they now have the certificate and they can access justice in precisely the same way that a multimillionaire could. There are a few caveats to that, like they'd have to find a lawyer who would take a legal aid certificate at the rate that legal aid pays, et cetera, et cetera. But that was the thinking behind it when the system was created. And to be clear, this was a magnificent step forward. Prior to the creation of legal aid, what you did is you had people who either relied on pro bono, that is somebody doing it for free or slumming it. So you had a corporate lawyer who decides to do a murder trial because they figure that's it's something that they're going to do in their spare time, or the court would appoint somebody to do a hearing, or people went unrepresented, which is actually what happened most of the time. So this was a spectacular step forward, the creation of legal aid in Ontario and in other jurisdictions. But there was also, and very soon after that, there was recognition that there were limitations to this model. And most fundamental was the realization that the legal problems of most low-income people and vulnerable people in our society are not the same as the problems of the middle class. In fact, not to go into too much detail, but there are surveys that polls that show that the average middle-class person in Ontario, or in Canada, sorry, has 6 discrete interactions with the legal system throughout their entire lives. You know, they buy a house, they incorporate a business, whatever. But for middle-class people, they're entirely discrete. That is not the situation for low-income people, not for the clients that I served, or for the ones that most of us who work in legal aid serve. The people who are in low income, in our society are constantly enveloped by law. As one much more articulate writer put, they are constantly bumping into sharp legal objects. That is the world of low-income and vulnerable people. And that specifically, that the problems that they tend to have are not discrete, but they come from the system itself. It comes from the fact, not that they are a bad person, but rather that they are poor and that they are powerless in our society, that they are not landlords and employers. They are always the people on the other side of the stick. And therefore, the solutions to their legal problems cannot just be individual, or else all you'd be doing is putting Band-Aids on 1,000 bleeding cuts every day, but rather that they are systemic in nature, and that the solutions have to be built that way. So at the same time that people were recognizing these critiques of the traditional legal aid model, new notions of equality were arising. And in society, and if you look at the literature at the time, we began to realize that if you really want to move towards equality, not just in the area of access to justice, but in that area as well, we need to understand the particular issues of the communities that we are serving, of the disempowered people, of individuals and communities that we are serving, and tailor our services to those particular needs. And that is what led to the birth of the community clinic model. Initially in the United States, some of you may be surprised to know, seeing what's going on down there, that was the birthplace of that progressive model. The United States in the 1960s, the late 60s, part of Lyndon Johnson's war on poverty. That was a point in time when governments had wars against poverty as opposed to wars on the poor, which has been more typically the case in the last 20 or 30 years. But during Johnson's war on poverty, they opened up these storefront community clinics across the states. And as with some other things, we came to realize, well, that's not a bad idea. Maybe we in Canada should adopt that. So there was a prime minister at the time who looked at that and thought, well, you know, I'll try that out. And his name, anybody want to guess what his name was? It's similar to the name of a prime minister that we have today. Anyways, it was Pierre Trudeau was the prime minister at the time. And he was talking in the United States, they were talking about the war on poverty. Here, what we were talking about was the just society. That was the motivating philosophy of the government in the late 60s and early 70s. And in the early 70s, they brought the community clinic model to Canada, and the federal government initially funded 4 different community clinics across the country. It quickly became apparent that this was a good idea, and communities were clamoring for these types of services. And here in Ontario, we were very fortunate that the Conservative government at the time, Bill Davis's government at the time, with Roy McMurtry as the Attorney General, thought that this was a good idea, and there were some really progressive people working within the Attorney General's department to Mercury's credit, he supported and gave enough space to do the work. And they developed a community clinic model through the mid and late 70s. And the community clinic model that they created, which was similar to the one in the United States and in England and Australia, it was based on 3 fundamental principles, and still is based on these 3 fundamental principles. And the 3 fundamental principles are this. First, that the clinic is governed by the community it serves. It's not governed by the Attorney General. It's not governed by the funder. Sorry, folks at Legal Aid. It's not governed by the lawyers who work at the community clinic. It's not governed by me, thankfully, for them. Rather, these are independent community-based organizations who are independent, entirely independent from the government and from the funder. And they are governed by boards of directors that are drawn from the communities that they serve. So it is those communities that determine what the needs of the community are and the services. And so for that reason, the services of a community clinic in Kenora might be different than they are in downtown Toronto, and for good reason. I'll get back to that one in a second. So that's the first characteristic. That's the community that governs the clinic. Second characteristic is clinics focus uniquely on poverty law, or sometimes they call it clinic law, but actually the term that's in the new legislation is poverty law, which are issues that disproportionately impact on low-income communities. So, I mean, some of that is obvious, straightforward. You can, of course, guess that community clinics don't do a lot of corporate law. They don't do a lot of maritime law. They don't do a lot of real estate law, but they do the law that that disproportionately impact on their communities. And in fact, they focus on issues where there is, and I'm being kind of quite colloquial here, but really where there's an us and a them, when it is absolutely clear who the us is. So for example, welfare recipients are the us, and the government, the welfare bureaucracy, are the them. Employees, non-unionized employees are the us, and the employers are the them. Landlord and tenant law, the tenants are the us and the landlords are the them. Those are the areas that clinics focus on because they are systemic community-based issues that have that disproportionately impact on the low income. And you know, it won't surprise most of you to know that as critical as criminal law services are and to be funded through legal aid, and they must be funded through legal aid, the vast majority of low-income people never set foot in a criminal court. The vast majority of low-income people, however, are on social assistance, or they are dealing with a landlord who tries to get illegal rent increases out of them, or they are dealing with an employer who does not pay them their vacation pay or give them proper notice or the requirements of the legislation. And low-income communities, these are the issues that they are disproportionately dealing with. So that's a second criteria, that clinics focus on those areas. And then third, clinics use a broad array of services to meet the needs of the communities. And what I mean by that, and this goes back to what I said about before about the prevailing ethos around legal aid, was that and access to justice, is that you can't just be doing individual work, putting band-aids on all the individual cuts. You must also be doing law reform, public legal education, educating people about their rights, community development. Clinics not only employ lawyers, but they employ community developers who organize the communities around the legal issues and educate them, and engage in law reform, test cases, pushing back, because you cannot simply fix the problems of low-income people by focusing on just the individual or the individual problem. So what do we have? We have a community clinic system that is one component of Ontario's legal aid system, and Simone's done a good job in describing that. And the clinics are just one component of that. And clinics are independent of, but yet funded almost entirely by Legal Aid Ontario, by the funding body. There are 72 community clinics in the province of Ontario. 55 of them serve geographic areas. every geographic area in the province is served by a community clinic. Now, to be clear, some clinics serve a geographic area literally the size of France. That's the Northwest Clinic in Kenora and Rainy River. But there is a clinic for every community. So every community, every person in every community can reach out to the clinic. In addition to those 55 clinics, there are 17 other clinics, which we refer to as specialty clinics, where the community is still a community clinic, but it's not defined by geography. So the Advocacy Center for the Elderly, for example, or the Disability Clinic, their communities are typically on a provincial level, but not geographic. The services are free for all who qualify, and the qualification is similar to what Simone pointed out, except there isn't one set of legal criteria. It can change from community to community. And what is important to the community of Timmins-Temiskaming is not necessarily the same thing that's important in downtown Toronto, although there are certain things that will be the same. And most clinics do social assistance, disability pensions, housing issues, in certain communities, refugee rights, basic employment rights, human rights. These are the types of issues that might vary a little bit from clinic to clinic, but those are often the types of services that the clinic will provide. And it could be anything from summary advice, public education, to representation, including up to the Supreme Court of Canada. And then I'll finish off by saying, and hopefully that gives you a bit of a snapshot of the clinics. I'll finish off by saying that there are many challenges that community clinics face, and I'll mention just two of them. The first is that there are never enough resources. You can see, those of you who have your cameras on can see the color of my hair, and I am old enough and have been in this game long enough to tell you about a time before when Simone and Rose were around, when actually legal aid funded a lot more than what Simone talked about. Legal aid used to cover many other programs, and because of cutbacks or restrictions over time, some of that has been lost. Clinics have felt the same amount, the same things as well, and with some exceptions, the funding has been relatively restricted. And as Simone pointed out, our current provincial government made some horrendous cuts in 2019 that had an impact on all legal aid services, including on the community clinics. So there's never, and even in the good days, there were never enough resources to meet all the needs of the communities we serve. And then my last point is the other challenge we often face, and won't surprise you based on what my previous comments were, are threats from governments. Because clinics, as you could tell from what we're talking about, quite often are either challenging governments in court, or we're challenging their allies and friends. And to borrow a phrase that was used in another area, when a clinic is doing its job right, it's giving power to the afflicted and afflicting the powerful. And when you do that, you don't earn friends in high places. So clinics have often felt that pressure. And I can tell you that the clinic system Ontario is the most comprehensive clinic system in the world, bar none. And that many other jurisdictions, both in Canada and elsewhere, have entirely lost their community clinic system because a government took the position that, well, why are we funding these people to make trouble for us, to get in the way of our agenda, our efforts to hurt low-income people? It's easier if they didn't exist. So here in Ontario, I like to believe that we're fortunate, and for a number of reasons, that we still have a community clinic model, and we're still in there fighting.
Thank you so much, Lenny. That was such a good overview. It's really helpful to have the historical context for how some of these ideas emerge and really how they're trying to respond to sort of our evolving understanding of what justice should look like and how to pursue our goals. So we started a tiny bit late. There's a chance that we may run a little bit past 4:30. Like I mentioned, if anyone needs to leave, we will be recording this. You're welcome to rejoin us. But for now, I want to flip to Rose to tell us a little bit more about how Courthouse Duty Council works.
Certainly, thank you. I'm going to try to share my screen now. Not very good at this, so I'm going to see what I have to click. Okay, does that work?
Perfect.
Okay, great. So thank you for having me. And my name's Rose, and I've been a criminal duty counsel with Legal Aid Ontario for 15 years now. So I just like to start off by sharing my first encounter with duty counsel. And it's a very embarrassing story. I was in first year university, and I had one of the assignments was to go to a courthouse and observe and write a paper about it. And I remember I was 19 and I went to a courthouse. I went to 1911 Eglinton, which is where I work now. And I remember going into a plea court and seeing a client, talking about his case, and he had a lawyer. And I was thinking to myself, oh, this poor client can't even pick his own lawyer. Is this lawyer even any good? And I was talking about duty counsel. So really a misconception of what duty counsel is. And I'm very embarrassed when I found that paper I wrote many, many years later when I'm working as duty counsel at Scarborough. So embarrassed about what I wrote. So I do want to say, and Simone talked about it very passionately in her talk earlier, what is the role of duty counsel, and specifically, what is the role of youth criminal duty counsel? So as Simone indicated, we are lawyers who work for Legal Aid Ontario. There is sometimes that misconception that we're not lawyers, but we do. We went to law school and we were called to the bar. We do provide free legal advice to people on their day of court if they financially qualify. So I do like the analogy that we are like a ER doctor. So we are pre-COVID working in the courthouse, and it's like an emergency room situation where we're the staff lawyer on duty, helping triage the flow of clients who come into the courthouse. A lot of people have never stepped foot into a courthouse, and we try to help them navigate the system. But specifically for youth duty counsel, we do provide assistance with bail hearings. So when you're first arrested by the police, you're brought into custody, we do help youth with their bail hearings. We also give summary legal advice. So on their day of court, and if they financially qualify, we will review their case with them and provide them some legal advice to point them in the right direction. And if necessary, we can also help them with negotiating the best possible resolution with the Crown. And those are called noted as Crown pretrials. And as indicated before, a lot of the cases are resolved outside of trial. So as a youth criminal duty counsel, we try to negotiate the best possible outcome for the young person without having the need to go to trial. In addition, we also help young people get their cases diverted through something called EJS, or extrajudicial sanctions. And I'll talk briefly about that later on in a moment. In addition to that, we also assist youth with guilty pleas. And I can say that as duty counsel for 15 years, I can count on perhaps two hands how many times I've pled a young person out. As much as possible, we try to divert cases. We try to resolve the case without a plea because of the potential consequences of a youth record that could have on a young person. I've also put stars in the slide, a Crown caution and a reprimand, and I'll go into that in a little bit more detail on the next few slides. In addition to the services I have outlined, as duty counsel, as the youth duty counsel, I also try to connect the young person to all the resources in the community and also the resources within the courthouse. So that could include connecting the young person to a youth mental health worker, to a school liaison worker with the Toronto District School Board, for example. And if it's an Indigenous youth, we hook them up with the Aboriginal court worker. And in addition to that, there's other resources that are very helpful, such as a diversion, a youth justice committee, the youth probation officers. So we really want to get the youth connected to try to help them solve their case in the best way possible. And as Simone mentioned, youth duty counsel, we don't assist with trials. So if it gets to a point where the young person's case is going to trial, or it's a bit too complicated, then we would suggest that the young person get counsel. And there's a section under the Youth Criminal Justice Act, Section 25, where if a young person is denied legal aid, they can appeal their refusal. to a judge, and the judge, according to the section, can overturn that refusal and have a lawyer appointed through the certificate process. So a young person has every right and has this very important right to be represented by a lawyer, be it duty counsel, be it private counsel, and certainly if the young person wants to take it to trial, they have the ability to get a legal aid certificate and hire a lawyer. So I want to give you an example of a case, and this is a case that is quite meaningful to me out of many, many cases that I've done, and it kind of explains in a nutshell what we do as a youth duty counsel. So I remember a time when I was in youth court, and there was a young person who came up, and I assisted him with getting his disclosure, getting his next court date. But there was something about this young person, and I saw his mom and his older brother in the gallery of the court. And I knew I guess just been working so long in the criminal justice system, you know, when there's a story behind the case. I saw that he was charged with an assault, and I told the young person after the adjournment, let's have a little chat outside of court, which we did. Got to review his disclosure with him and got to get his side of the story. And in a nutshell, the case was where his older brother and his mom, they were all charged in an incident where the mom had returned the rental car to the rental agency, perhaps 5 to 10 minutes late. And so the car rental agency wanted to charge the mom an extra day for the car rental. There was a lot of arguments back and forth. Ultimately, mom was charged with assault with a weapon, and the young person was charged with assault, and his brother, who was an adult, was charged with assault as well. So I got his side of the story, and essentially he thought that his mom was being bullied and assaulted by the car agency staff, and he was trying to come and defend his mom. And I read the disclosure, and the way that it was painted by the police synopsis or the police summary, it didn't show exactly what happened. So I got his side of the story, got him to tell me a little bit more about him as the person, because as the youth lawyer of the duty counsel, I want to be able to present his side of the story, but more importantly, to bring out the person behind the name, behind the charge. I went to a Crown, explained his version of events, told him this is the young person's first encounter with the police, never been charged before, a good kid. And the Crown took what I had to say, got some input from the officer in charge, and decided ultimately, after he brought in some reference letters, school transcripts, that kind of thing, he decided to withdraw the young person's case. The mom had to sign a peace bond, but ultimately her charges were withdrawn as well, likewise with the brother. So that is an example of what we do for a case where we can review the disclosure, get the story, negotiate with the Crown, and get the charge withdrawn. And I remember this mom a few months later during Christmas time, she called me just to say, is there anything I can do? Can I give you something? Of course, I can't take anything, just doing my job here. But she said something to me where, my son said after his whole experience, he wants to go to law school. He wants to become a lawyer and see how he can help other people who are who get involved with the criminal justice system. And to me, that is just, sometimes duty counsel, you're so bogged down with the hundreds of cases that we do. And these are the cases that really make it worthwhile and meaningful. And I think about him from time to time, and hopefully one day he does become a lawyer and help out with Legal Aid Ontario. So I want to move on to what's called, I mentioned earlier, what's called extrajudicial sanctions, or EJS for short. And it's a way for the criminal justice system to divert young people from the court. We don't want young people in the court. It's different from what's called extrajudicial measures. So this is something, for example, where a teenager, is caught stealing something from the store. Police are called. Police can attend to the store and say, well, I'm going to exercise my discretion. I'm going to give you a caution. I'm not going to charge you, but don't do it again. So that young person is not even going to get anything and not going to need to go to court. But if the police officer does decide to lay a charge and now this young person has to come to court, the Crown can look at the case and decide to divert it. So divert it out of the criminal justice system. And so as Youth Duty Counsel, if we get a case screened for EJS, we would sit down with the young person, go through the synopsis or the disclosure and see if this is something that the young person can take responsibility for. And if it is indeed something that he or she can, the young person can sign up for the diversion program and meet with the youth worker. They set up something for them to do. It could be community service. It could be a stop shoplifting program, or it could even be if the young person was charged with a minor assault to meet it's like a mediation, a youth justice committee mediation, where the young person and the victim or the complainant would meet and talk about what happened and find a middle ground and try to understand both sides. And then ultimately, when the young person finishes this program, the charge is withdrawn. What I put here on the slide is that the record is kept on file. So the record that the young person completed EJS is kept on their youth file for 2 years. And I started that because I wanted to draw your attention to that. It's very important. And I'll explain a little bit why. So say, before I talk about that, but say a young person is not offered EJS. So the young person is required to plead guilty to their case. These are some specific outcomes that could happen if a young person pleads guilty. I won't go through all of them, but you can see listed what's here. But I put a star beside reprimand. And what a reprimand is that, say, for example, a young person is charged with assaulting his sister, and the police lay a charge. The young person can actually be offered a plea deal to plead guilty. And the sentence or the punishment the Crown is seeking is called a reprimand. And this involves the judge kind of waving his or her finger at the young person saying, don't do this again. And that's it, that's the sentence. Why the youth sentence or the outcome is important is because of this particular section in the Youth Criminal Justice Act, under section 119 subsection 2, periods of access. Again, I won't go through the entire list. You can see here what the period of access is depending on the outcome. So I guess something to think about as a Youth Duty Counsel is what is the best outcome for the client? So you'll see if the client finished EJS, the record that this client took part in EJS will stay within the period of access for 2 years after the young person completed EJS. So that means if within 2 years, the young person, within 2 years, if someone wanted to get access to the records, and the Youth Criminal Justice Act outlines who may be entitled to do so, if they try to access that within the 2 years after the EJS is completed, they can. But you'll notice if a young person got a reprimand, so finger waving by the judge, or the charge got withdrawn, then it only stays on the youth period of access for 2 months. So these are kind of things to think about. What effect should the outcome have? How long will the outcome have on the young person? I wanted to note here at the bottom of the slide, I put the effect of an adult conviction on a youth record. So I've noticed a lot of times that young people come when we speak to them at court, and we ask them when they're over 18, so do you have a record? And they said, no, I don't have a record. But in fact, that when they were under 18, they had like many dealings with the criminal justice system. And in fact, they had many entries. But they thought that once they turn 18, that record is entirely gone. It's not true. In fact, it depends on the period of access. So just a quick example, if an 18-year-old is charged with an offense, and he or she's planning to plead guilty just to get it done and over with, we really need to look and see, is there a youth record out there lingering? And is it still within the access period? And so the question will be, if the client pleads guilty within that access period, then the youth record will remain a permanent part of that person's record. And this is a huge effect on a young person. So I thought that would be something interesting to highlight and bring up to share with you. So finally, I wanted to just indicate what we do primarily as Youth Duty Counsel, are bail hearings. So bail hearings are a very, very important stage of the criminal proceedings, determines, you know, often how the case would proceed. If you get bail, you can have time to set trial dates and fight your case at trial. But if you get denied bail, you're stuck in custody, and that changes kind of what you wanted, your next steps would be. So in a bail hearing, what that means is after the young person's arrested, is held in custody, brought to court, and in all youth bail hearings, the Crown Attorney bears the onus to show to the court why this young person should be kept in custody. Why is it a risk for this young person to be released back in the community? Some things to keep in mind in the youth criminal justice system: detention is the last resort. We don't want young people in jail. So as duty counsel, we fight as much as possible to get them released in the least restrictive sense. And a lot of times I find in my experience with working with youth in custody, a lot of times there's no plan. There's no plan to get them out. There's no parent to help them, for example. But something to keep in mind: the youth justice system is not a place to substitute for child protection or for mental health issues, because the young person is not getting any help in the community. So you know, let's keep them in jail so they can at least get some help, or for any other social measures. That's not the case. So we need to get the young people on bail. Something that's also different in the youth court is that there's something called a responsible person. So what that means is in the adult system, if you're trying to get bail, you'll have a surety, possibly, who could come and bail you out. And in a young person's case, if the lawyer has exhausted, you know, all possible bail plans, and the justice of the peace is just not buying it, this young person has a terrible track record, there's something called a responsible person. And what that means is, well, you can propose someone to be a surety, but in addition, if the young person does screw up on bail, then this responsible person could potentially be charged criminally as well for not ensuring that the young person follows through. So it's just an extra layer, I guess, an extra chance for the young person to try for bail. And then finally, just wanted to wrap up in terms of the bail. There's something called a bail de novo. So the difference in that is, in the adult system, if you get denied bail at the first level of the Ontario Court of Justice, you could apply for an appeal at a higher court, but that could take weeks to happen. But for a young person, what's different is if you get denied bail by a justice of the peace, you can apply for new bail within 3 days. Again, that reflects just the fact that we don't want young people in custody. So there's all these safety measures that can address that. And then finally here, I put a referral to Children's Aid. It just means that if a young person doesn't have a guardian or parent who comes to assist with bail, duty counsel, we are obligated to call Children's Aid to ask them to assist as a guardian. So I spoke very quickly. If there's any other more information, please feel free to reach out, or you can check out these websites here that provide some very useful information. And then finally, I just wanted to say thank you to all the teachers. I was really excited to speak today because I actually remember when I was in grade 12 and I took my law class, and I was very inspired by my teacher. And I just wanted to say thank you for all that you do for the young people today.
Thank you so much, Rose. That was really, really, really helpful to hear. We have a number of teachers still hanging on the line. I'm going to give them a second to submit if there are any questions before we go. I do have one or two here, but I'm also mindful of the time. We have someone's asking about trying to keep young people out of custody. Is this is this just a policy of duty counsel, or is this an idea that exists in other places in the law?
Oh, so definitely not particular to duty counsel. It's very much a principle of as part of the law under the Youth Criminal Justice Act. We don't want young people to be in custody. We want to focus on rehabilitation and reintegration.
That's great. I guess maybe as a last question, unless anything else rolls in, all three of you have worked for quite a while in and around the legal aid system. Why do you guys think lawyers choose to work in the legal aid system in your experience? I realize this is a big question. It'll vary for different people, but what do you think?
It's obviously it's the money. It's the
Oh,
big
yeah.
bucks.
Absolutely.
You know what, my first day in law school, I went to law school to go into health law and public policy. That's my background, is actually in sciences. Like, I have a Bachelor of Science, and I went to Dalhousie because I said, okay, well, I don't know what to do with my life, so I'll go into government and do something policy wise. And I felt strongly about things like assisted suicide. That should have maybe given me anyway. So my first day, I had my first class, and that was criminal law. And 20 minutes in, I looked around at my classmates, and all I could think was, oh my God, we're all going to apply to jobs in criminal law, and there's going to be no jobs left because everyone's obviously going to want to only practice this and defend people. I'm not kidding you. That was literally, it was like a giant bug just bit me right then and there. And I called my dad, who's a lawyer, after that first class, and I was like, well, I'm going to be a criminal lawyer. And he's like, you've taken one class. I'm like, yeah, no, I'm good. And I was I ended up summering, and I didn't get a criminal law job first time around. I ended up I actually summered an article at a labor law firm, which was really interesting. And they offered me an associate position in 2010, by the way, which was the massive, when everyone was fired and all the law firms were it was the giant recession. And I took it because my dad was like, you got to take a job. And I was like, okay. And then I did it for 2 months. And my partner, who's really quite smart, he just was like, if you love something, you've got to turn it down. You've got to go and do something social justicey, which is what you want. So, in terms of, I'd almost say social justice kind of picked me, systemic advocacy and criminal justice. I also thought I wanted to be a crown in that first little bit. And it was one day, or maybe two, but probably not, one day of being duty counsel when I realized I wanted to fight the system as opposed to being part of it. That's my story.
Makes sense.
My sense is that the first year of law school, 80% of the law students in year one all want to be Atticus Finch, and they went to law school because they were going to change the world. And then the second year, it's probably down to 40%. And then the third year, it's the 20%, the people who all end up doing social justice and legal aid type work. And it's because most of those people, and I still regularly speak to law students, and I don't think it's changed those numbers haven't changed in a significant amount since I was at law school. And I think that for that 20%, that's why they're lawyers. I mean, quite frankly, for me, if I didn't have the opportunity to do social justice work, I would have been a bike courier. It's not, I would have never worked at a corporate law firm. It's just not, it was never an interest, and not something I would have gone to, that I went to law school for.
Fair enough.
Yes, I never thought I would be a criminal lawyer, quite frankly, but I knew that corporate law was not for me. And when I went to law school at Queen's, I did have a chance to work in the Queen's Legal Aid, or the student clinic office, and I really enjoyed that work. And I signed up to be duty counsel for a 3-year contract, and I'm now here for 15 years, and I just love it wholeheartedly. I miss being in the courthouse, quite frankly. Virtual court is very different, and I just appreciate and enjoy helping people navigate this very difficult system, and hope we can go back soon.
There you go. So these are the lawyers that your students will meet if they ever come to depend on the legal aid system. our very last question, and then we'll wrap up. This has come in from Tanya. She says, hello, thank you for this amazing presentation. Do you find that there's family support for young people, especially working in Scarborough, where there's a huge marginalized community? What kind of supports are there for young people going through family law processes?
So is it support for family law or for support for young persons?
I think it's for young people who are involved in family law processes. Oh, she's clarified, support for young people, yeah.
In the criminal court?
I think we're talking about in family court context and in Scarborough, ideally, yeah.
So I don't actually know specifically what family law services. If there's a family court, then there's definitely a family law information center at that court. So I would suggest going there. There are duty counsel who provide full summary legal advice there. So that would be a great first step, and DC are crazy knowledgeable about where to go and what to do. And if you need more help, they're very linked up with community organizations. So criminal court context to families attend to assist with such things. So it's interesting because, and I mean, Rose can speak to a little bit of this, the duty counsel and staff lawyers represent the youth, right? And sometimes what happens is the family and the youth, and I've had this actually happen in the adult context as well, where family members are really pushing for a specific thing, like, oh, just plead guilty and get it over with, just plead guilty and get it over with, or just do this. And they're not your clients. So what we really like to do, especially in the youth, and I'm going to let Rose actually take this because this is her bailiwick, but I can just tell you from from a high level perspective, it's important that the person feels supported and not frightened. Like, you don't want the person to feel like they're alone talking with some lawyer that they don't trust, but at the same time, it's really important to make sure that you're getting instructions from the client and not from the client who's being pressured to say something from their family, which sometimes happens and sometimes doesn't, but I'll let Rose kind of handle that one. This is exactly what she does on a daily basis.
Totally agree with Simone. I actually started my presentation, but I forgot to mention it. We do need to ask the client if they feel comfortable speaking to us alone. If they don't, if they want their parent in the room when they talk. But I do have the same experience where parents pressure the young person, you know what, just take the EJS program. You'll get it done. You don't have to go to trial. And the young person trying to tell me, you know what, I didn't do anything wrong. I was defending myself, or I never took the item. So I have to take instructions from the client. And if I see that the parent is trying to get in a word, it's not jiving with the young person's interest, I have to take the young person aside and speak to him or her privately.
All right. I just want to say one more thank you to all of our panelists who've made time today to come and share this. This has been really, really useful. And I know our teacher audience is really going to appreciate having access to everything that you've just shared. So thank you once again for any teachers who are still hanging in. You can subscribe to our newsletter for updates and announcements of future webinars that we'll be running, and look for this link to appear on our YouTube channel in the next couple of days. Otherwise, everyone, please keep safe and be well, and we hope to see all of you again.